Hi, this is Mark Herbert from Herbert Law Office. We've been serving California families since 1995, and we can help you and your loved ones avoid the costs, delays, and stress of probate court and unnecessary taxes through estate planning. This webinar is called What is Estate Planning and Why Do I Need It? So please feel free to take notes, write down any questions you might have during the webinar. But before we start, I just want to give you a quick description of my background and our unique approach to estate planning. All right, so this is an estate planning boot camp. Again, it's very brief. There's a lot of information in a short time. But before I get into the information, let me tell you a little bit about myself. Way back when I was born and raised in San Fernando Valley, finished high school when I was 17, went straight to college, got my degree in 4 years, went straight to work. And then I worked as a social worker for about 6.5 years with developmentally disabled adults. We had 42 clients, all of them completely different people. So in that role, I was trained that my job was to find out my client's situation, give them some options to make the situation better, let them choose the options they like, and then go and build a plan that was customized to their exact needs and wants. So had absolutely no interest in being a lawyer whatsoever until I was 28 years old, and I watched a lawyer's mistake blow up on one of my clients, and he inherited too much money the wrong way, and it created massive problems for him, for his family. So decided that we would go to law school. So we went down to San Diego. My wife, our daughter, and I went down to San Diego School of Law, did a 3-year program in about 2.5 years, passed my bar, and then I came up and started working here in Lancaster. Worked for a couple law offices, did about 6 years of an apprenticeship, as I see it. Got really involved in the community. We did coaching, we did band boosters at the high school. We were involved in scouting. I got to sit as a temporary judge probably twice a year for a whole week for about 10, 12 years. Have been involved in lots of different charities and programs throughout. But in my first job, I sort of took that mindset of that the client is really in charge into that job. And my boss for the first 2 years really wasn't client directed. He was very attorney directed. You very much controlled the process, and he pretty much pushed people to a plan that he was most familiar with and comfortable with. So it was good for him, but it wasn't always good for the client. So after a couple of years, I moved over to a different firm that was very client directed, which is good. That's sort of my approach anyways. But the problem at that office, and lots of lawyers do this, is that they did hourly billing. So the longer you talked, the more questions you asked, the bigger your bill was going to be the next month. And then I could see it in talking with these folks that they had questions. There were things they weren't sure about, but then they'd look at the clock and you could see them sort of doing the math in their head. So that wasn't good for estate planning, or as I like to call it, family wealth planning. And there is a difference. We'll get into that here in a second. But so I started my own office 21 years ago this month with 2 simple rules. Rule number 1 is the client is in charge. Everything we do is directed by the client. I still see my job as finding out your situation, giving you some good options, letting you choose the options you like, and then that's what we build for your family specifically. Rule number 2 is that there's a flat fee based on the options you choose. So nobody has to worry about how long we're talking on the phone or in person. Nobody has to worry about a 3rd or a 4th draft. Everything is handled, in that one flat fee that's chosen by the client. So it works out much, much better, and we are able to help a lot of people. So I did just reference the difference between estate planning and family wealth planning. So estate planning is sort of the traditional approach where the lawyer controls the process and you end up with, 200 pages of information, 15, 20 documents, and you don't really know what's in there, but you know that when you pass away, you're going to transfer your assets and it should be okay. But you're very confused. That's fine. I found a better way though, and we call that family wealth planning. It's a new approach that focuses on controlling your assets and growing your assets during your lifetime, and then transferring those assets without probate court, without the so-called death taxes, either postpone them, delay taxes, exert a lot of control over the timing and the amount of any taxes. Most important in family wealth planning, the client controls the entire process. And you end up walking out with, 4 documents or 7 documents that you fully understand because we've gone through them page by page a couple of times. And there's lots of good options that we talk through. So you know that your plan is perfect for your situation and what you want. And then for those of you who have kids under 18 under your care, we also have what's called the Kids Protection Plan. I've raised 3 kids. They're all adults now, but I understand there's a lot more to raising kids than just putting food on the table or giving them a bed to sleep in. There's educational concerns, financial concerns, medical concerns, lots of things going on. So we also include that in the family wealth plan. It's not just about guardianship. It's about a higher quality of life for your kids if something were to happen to you unexpectedly. Now, sometimes I'm talking with folks and they find out what I do, and we talk about family wealth plans, and people ask me, well, why do I even need that? That sounds really complicated. That sounds really expensive. It sounds like it takes a lot of time. And the answer is it doesn't really take a lot of time. It doesn't really take a lot of money. But more than that, it's really about protecting your loved ones and protecting your assets from probate court and taxes. We're going to talk in a few minutes about what happens at probate court, why it takes so long, why it takes so much money. So by comparison, doing an estate plan on the front end, so to speak, ends up saving a lot of time, money, and stress on the back end, so to speak. So, basically, rule of thumb is if you own any land in California, like your house, you probably need an estate plan. If you have kids of any age, you probably need an estate plan. If you are single, you probably need an estate plan. Because if you don't plan for the end of your life and the passing of your assets, California has a plan for you. And that plan is called probate court. And then as soon as you're done with probate court, the tax man will be with you shortly. So, every person, every couple has unique needs, different stages of life, different concerns. Sometimes there's a disabled heir. Sometimes there's a blended family. Sometimes you're an older person who's trying to provide for grandchildren or even great grandchildren. Sometimes you're a young couple and you just want to make sure that your young children are protected. So to put everybody into the same plan is really destructive and can have really bad consequences to the client. And that's certainly something we don't want to do. So I've called this Family Wealth Planning Boot Camp, basically taking 170 years of California law and my experiences as an attorney and condensing it down for you in about 40, 45 minutes. So we are going to talk about what I call the 4 pillars of a family wealth plan. We're going to talk about the difference between a will and a trust and which one you need. And then we'll talk about several different ways to avoid probate and to transfer assets with minimal or no taxes. So again, please take notes. Please write down questions. Again, we're not taking live questions today for your privacy, but I do want to answer those questions when we touch base with you later on. All right, so the first pillar, in my opinion, something that everybody should have is what's called an advanced healthcare directive. This is simply a set of written directions to your doctors about what medical treatment you want and what medical treatment you don't want, plus naming a trusted agent who's going to enforce those wishes. So I like to reassure people all the time, if you're verbal, you control the process. If the document says one thing and you say something different, what you say in the moment controls. So long as you have capacity, you control the process. So lots of times we will put in information about medical treatment for end of life, hospice care, palliative care. There's options for DNR, do not resuscitate orders, organ donations. There's HIPAA waivers in there. So there's a lot of attorneys who like to do all of those things in separate documents. I've recently reviewed what should have been one healthcare directive that was spread out over 5 different documents. There's no need to do that. In a panic situation, in an emergency, you want your loved ones to have the right information in one document at one time, ready to go. So we condense everything into the one document for you. You need to know that there is an immediate advanced healthcare directive if you have a current significant medical situation, or you can have what's called a springing power, which only takes effect in the future if you become ill or injured and incapacitated. So whichever you prefer, there's a lot of options. Now, according to the CDC, most adults will be incapacitated at some point during our adult lives. And we've had dozens of clients come back and tell us how thankful they were that, in that awful moment, in that awful situation, in that room, it was a comfort for them to know that they had a written set of instructions to help their family member and respect their final wishes. So it gives you peace of mind, but it also helps your family, just in case. If we've learned anything from this whole COVID pandemic, is that anybody can get sick at any time. Accidents happen all the time. So it's good to be prepared and take care of things in advance, especially when it comes to your medical needs. Now, the second pillar is similar. It's a financial power of attorney. So where the healthcare directive helps with your medical needs, a power of attorney helps with your financial needs. So it can be immediate or springing, just like the healthcare directive. You can also do limited powers, where an agent has authority over certain transactions, like paying your mortgage, or more general powers where they can handle most or all your transactions if necessary. So this is a written set of directions for your agent that you trust, that you choose to pay the bills, to deposit checks in, to handle whatever transactions you want them to, in case, again, you're ill or injured. So one of the big advantages of these 2 documents is that your family can avoid what's called a conservatorship. So if somebody gets really, really sick, with the rise of dementia cases and Alzheimer's cases, as people get older, sometimes they have a hard time remembering their medications, remembering their doctor's appointments, paying their bills, handling their money. Sometimes people take advantage of them and get money out of them the wrong ways. So by having the healthcare directive and the power of attorney, you can avoid all that. The only person that's allowed to help you is the person you chose, and to the extent that you want them to. So otherwise, you might have to go to court for a conservatorship where the costs are greater, the delays are greater, the stress is greater than even a standard probate case. So the third pillar is a will. Now, wills recently have sort of gotten a bad reputation. And I think it's because people are confused. There's actually 2 different kinds of wills. One that's good for most people and one that's not good for most people. So what is a will? A will is a document that allows you to make an immediate one-time transfer of property to the heirs of your choice. Okay, again, you're choosing who's your heir, you're choosing what do they get. So sometimes that's jewelry or a car or family heirlooms, a piece of furniture, something of great sentimental value that you really want to give to someone specific. So you create a will. That's where you would name guardians for minors under your care. You can also provide directions for your funeral or celebration of life, as well as any burial instructions or cremation instructions. So that's the underlying purpose of a will. Now, if your will is just on its own, what I call a standalone will, there is a disadvantage of a simple will, especially if you're trying to transfer land. And the major disadvantage of a simple will is it might easily land your family in probate court. So when I started law 27 years ago, the rule of thumb in LA County was a year and $10,000. Not that bad. Not that fast, but not that bad. I would say about 10 years ago, 12 years ago, it doubled, basically. The calendars got really, really crowded. And these days, it's more like 2 years and $20,000. But then over the last couple of years, due to the pandemic especially, it's more like 3 years and $30,000. The other major problem with probate is if you have property in multiple states, and a lot of people do, your family is going to have to go to all those states and do what are called ancillary probates. So if you have property in Florida, Michigan, and California, your loved ones are going to have to do probates in those 3 different states, hire attorneys in those 3 different states, and go through the entire process, some of which will not match up. But equally bad in my mind with a simple will is if you have young heirs, under 18, or in my opinion, under 25, they're going to get the full inheritance immediately if there's only a will. So regardless of their needs, regardless of, if they're able to handle it, the will is going to immediately transfer that property. And again, if it's land, there's a bunch of tax laws now that are going to hammer these young heirs who may not be ready to handle a lot of money all at once. There's a better way of getting those assets to them, and we'll talk about that in just a minute. But still, having a will, a simple will, a standalone will, is better than not having a will, because if you don't have a will, there's no direction for the court. Somebody has to file a petition in court, and the judge is going to enforce what are called intestacy laws. So if you have a last will and testament, right, you are the testator. If you don't have a last will and testament, you are intestate. You have no will. So then California decides who's your heirs, what do they get, and when do they get it. So what you want doesn't matter. You're going to be dropped in the California system, rattled around, and 3 years and $30,000 later, spit out the other side. Especially if you're a single person, there can be a lot of disputes and people doing things that are not good with your property. So on the right-hand side of your screen, you can see a hypothetical. So let's say that Mr. Smith is 30 years old. He's got a piece of property in his name only, and he marries Mrs. Smith. And then by the time he's 35, there's a couple little Smiths running around, child 1, child 2. And then at age 40, Mr. Smith dies in an accident, having never changed title to the house. Now, a lot of people tell me that's community property, so everything goes to wife. First of all, that's not community property. It was property before their marriage. She does have an interest in the property, but it's not 100%. It's not community property. And you do have to go to court for community property anyways. A lot of people think you don't have to go to court on community property, but you actually do. So, but in this example, Mr. Smith never changed title. It was always in his name. So under California's plan, Mrs. Smith only gets a third of that house that she's lived in for 10 years. She's helped make mortgage payments, utility payments, insurance payments, repairs, maintenance, all of it. So she's going to get a third, and then the other 2/3 is going to be divided among Mr. Smith's biological or adopted children. So in this example, the 2 children with Mrs. Smith. But let's say, that maybe this is Mr. Smith's second marriage, or he has a child from a prior relationship of some kind. Those biological children also have a right to the property, part of that 2/3 that's left over. So surviving spouse definitely has an interest, a small interest, and then the 2/3 gets divided among his biological children. If they're under 18, people have to become guardians for the court to handle the money, to handle title on the house, if the house is going to be held on to. It's just a lot of problems can come out of that process without a will. So there's got to be ways to, stay away from probate and transfer assets quickly, inexpensively, and in a much less stressful situation. So there's lots of ways to do that. You can own property jointly with somebody else, like a joint bank account, where when somebody passes, title just goes to the survivor, quick and easy, no court, probably not taxes. But you have to be careful with Proposition 19. If you own land jointly with somebody, there may be taxes, even though there's no court, there may be taxes. And if that heir is a non-spouse heir, there can be a lot of taxes for them with regard to land. Land is a very unique asset, and you have to be very careful with it. You can also do beneficiary designation. So in your life insurance, IRAs, 401ks, you can decide who is going to be the beneficiary of those. You designate that, and then when the time comes, the company just writes a check to whoever you told them to. So again, it doesn't have to go to court, but there can be taxes, there can be penalties if the heirs decide to pull out all the money of a 401k or an IRA, for example. And then you have to be careful of what's called the Secure Act. For any non-spouse heirs, used to be they had a lifetime to draw out that money. Now with the new law from 2019, they only have 10 years for most retirement accounts. Another great way to avoid probate and to transfer assets correctly is to use lifetime gifts. So as an individual, you can give up to $15,000 per person per year, tax-free to both sides. As a married couple, the limit is $30,000 per year per person. But for me, the best way in my mind to avoid probate and taxes is to use a second kind of a will called a pour-over will, and then you attach it to a trust. So a pour-over will does all the good things that a will does. You get to choose your executor who's going to enforce everything that's written in your will. You get to name the guardians. You get to make your funeral and burial arrangements as specific or not as you want. You get to make specific gifts to your family and friends. However, everything else pours over into your trust. So the will acts sort of as a safety net, if you will, on the trust. It still does all the good things that a traditional will does, but doesn't have the risk of the costs and delays and the stress of probate court. So that sort of pushes us into the fourth pillar, which is a trust. So what's a trust? I like to tell people a trust is basically a personal corporation. And much like corporate law in business, there's tax laws that favor corporations. Well, in our personal lives, there's tax laws that favor trusts. There's a lot of them. And if you're married, there's even more of them. But a trust itself basically allows you to manage your assets, grow your assets during your lifetime, and then you control who receives those big assets. Things like land, bank accounts. You can aim life insurance or IRAs or 401ks at your trust if you want to. And that really helps younger heirs to not inherit too much money right away. If you use the trust correctly, you can actually distribute assets over time. So for example, 20% when the heir is 18 years old, 20% when they're 21, 20% when they're 25, and then the rest at 30. We were just working on a plan today with those numbers and percentages. That way your young heirs get some money when they're young. They're going to make mistakes, but they make smaller mistakes. And then by the time they get the bigger distributions, they've learned and they manage the money much, much better. Also, trusts help provide for minor children, older parents, any heirs who are disabled. Everything stays private with the trust. It never gets filed in court or anything, and you have full control over the assets so you can better protect your loved ones down the road as things change. So in California, there's two kinds of trusts. One that you can change, commonly called a living trust, and one that you can't. commonly called an irrevocable trust. So a living trust, a revocable trust, can be changed anytime, any reason, any way. So if there's a change in your family, it's easy to amend your trust. If there's a change in your assets, if there's a change in state law, federal law, change because you just want to make a change, that's fine. You have total flexibility and control. These days, the only time you really want an irrevocable trust is if you're going to make a massive donation to your favorite charity, if you have a disabled heir who needs a special needs trust, or you have children from a prior relationship that you want to protect even after you're gone. But you got to be careful. Trusts are very powerful tools. And like any tool, if you misuse it, you can really do a lot of damage. I sit down almost on a daily basis and review the work of other attorneys or some of these internet places or document preparation places that almost get it right. They almost have it perfect, but maybe the laws have changed. If you have a plan that's more than 3 or 4 years old, the law has changed. State law changed, federal law changed. So you need to update that trust to reflect those changes. So you need to sit down and go through your entire financial situation before you build your trust. Otherwise, again, if something falls through the cracks, you're looking at probate and taxes. So what is a trust? A trust, again, is like a personal corporation. It's created by what we call settlors or trustors. It means the same thing. That's the person who are creating the trust and funding the trust. You got to write it down. There's no such thing as a verbal trust. You have to write it down. It has to be on paper, and then you have to fund it. A lot of the times I'm reviewing other people's trusts. I go to look for the assets that are in the name of the trust, and I realize that there are no assets actually in the name of the trust. The deeds weren't filed, or the banks weren't notified, or the life insurance company still has the old beneficiaries. All that has to be handled when the trust is signed. A trust also has fiduciaries called trustees who manage the trust. So for your trust, you're the initial trustee. You have management over the trust and its assets. Down the road after you pass, your successors cannot change your trust, but they do manage the assets to the extent that you allow them to, with some discretion. Finally, you need beneficiaries on your trust. Who's going to inherit the assets? Again, during your lifetime, you're the initial beneficiaries, but then who do you want your heirs to be? And many times, people will just give one level of beneficiaries when really there should be at least 2 and probably 3, because you never know. A beneficiary could pass before you, and you need to have a plan B or even a plan C, in my mind, in case that happens. Lots of plans don't do that. They'll name one successor trustee, one set of beneficiaries, and that's it. And that creates a lot of problems, the potential for a lot of problems. So I do see a lot of mistakes. One of the things I see a lot is a failure to use asset protection provisions. There are things you can put into your trust to prevent your creditors or the creditors of your beneficiaries from coming and trying to attach something onto your assets. Another thing that happens a lot is that all distributions are mandatory. You must give child 1 this much money on his 21st birthday. In my opinion, you should have some discretionary powers for your successors. Yes, that's the plan, but what if that child needs money ahead of time for an educational opportunity or a medical need? Can your successor advance the money? Can they also delay the money? Can they also stretch out the distribution over a couple years maybe to avoid taxes? If you make it mandatory, you're kind of handcuffing your successor. Again, many times people don't have contingent beneficiaries, the plan B, the plan C, which I think is always a good idea. Lots of people still use co-trustees, co-executors, co-agents, and that's fine generally. But I'm in probate court every week. And one of the most common things I'll see is a co-trustee situation or a co-executor situation where one trustee wants to sell the house, one trustee wants to keep the house, and then there's conflict, and then there's litigation, and then you're going to court, and everything gets mangled. But then also, probably the worst thing I see is just a complete failure to avoid taxes. There are some exemptions right now on the books. The marital exemption is currently $11.5 million, but you got to write it down. You got to present it the right way in your trust. Lots of these discount places don't even mention it. It's an $11.5 million tax break per spouse. You should write that down. You should take advantage of that tax break. And then with California law, Proposition 19, of course, which basically triples property tax for non-spouse heirs in certain situations. There's ways to avoid those taxes if you write them down correctly. So in some ways, Proposition 19 was really a mixed blessing. I mean, for people like me, 55 and over, there are some nice benefits if I go off and I buy a new, more expensive property. That could save me a lot of money. But people my age, 55 and over, usually aren't going out buying new, more expensive properties. The nest is empty or will soon be empty. A lot of people are downsizing. So Proposition 19 will not help people 55 and over who are buying new, less expensive property. Will be subject to Proposition 19. But the worst part of Proposition 19 is for non-spouse heirs like my children. They're all adults, but they're not going to receive a tax break if they use that house as a second home or a rental property. So the property tax is basically going to triple on them in many cases, which is just crushing debt. It's hard enough to be a young adult in California with all the taxes and everything that's going on, but then to lose the protections that we've had under Proposition 13 for non-spouse heirs, it's pretty awful for people who want to give property to young heirs like that. So most of that can be avoided by doing a living trust, by building a family wealth plan. Again, if you know what the law is and can maneuver through the law and actually follow the law, then you can get away from a lot of these taxes. So a question I get all the time is, what's the difference between a will and a trust? Well, we sort of talked about that already. A will is designed to do some things, and a trust is designed to do some other things. So if you're looking to do a one-time immediate transfer of a piece of jewelry, that's probably going to go through your will. If you need to name guardians for minors, then that's clearly a will. If you want to make funeral arrangements, if you want to be buried somewhere special or scattered somewhere special, that's all through the will. But if you want to do distributions over time, if you want to protect disabled heirs with a special needs trust, obviously that's a trust issue. If you want to transfer real property, land, especially in multiple states, the best way to do that without having someone go and probate in all those states is having a living trust. If you want to avoid court, if you want to avoid taxes, if you want to get that marital exemption, that's what a trust, that's where a trust really shines. And so what often works best is a pour over will and a living trust. The two put together are really, really powerful in protecting your loved ones, protecting your assets while you still have full control. So sometimes I talk to people and they're a little nervous coming in to talk to the lawyer. At Herbert Law Office, we strive to make everybody comfortable. We've got bright, nice offices. We'll get you coffee and water and snacks as much as you like. But more than that, what we'll do is we'll sit down with you and we'll talk. And you're in control every step of the way. So what we do is, again, just like when I was working before law school, I still see that approach as helping people. Find out your current financial situation. Talk about options that are available to you. If you have something already in place that you like, we leave it alone. Then you get to choose the options that work best for you. Everything's personalized for your family and your asset structure. And then based on the options that you've chosen, that's what determines the fee. But we also offer a lot of discounts. I'm from a military family. Two of our kids are currently serving in the military. I have a lot of friends who are veterans, a lot of friends who are first responders and teachers. So to show our appreciation, we do offer discounts for all those people. And yes, you can double up on those. I do have friends who are, veterans and involved in law enforcement. So we do offer 2 discounts for that. They're serving the community, they've served the nation in 2 different roles. So yes, we offer 2 different discounts. So sometimes people will call me and they'll say, well, what is the fee for this? My answer is, I don't know. It depends. Once I know your financial situation, once you're advised of your options and you choose the ones you like better, then I can give you a fee, but oftentimes it's going to be a discounted fee. And then once we're hired, we have a really fast, efficient 5-step program that gets you an estate plan put together in 30 to 45 days usually. But again, you're in control. Some clients want to go faster, and that's okay. Some clients want to go slower, and that's okay too. You're in control every step of the way. All your questions are being answered. All the loose ends are being tied up.
So that's the essential information that you need to begin thinking about your own estate plan. I hope that you wrote down a lot of notes, wrote down a lot of questions. And if you're ready to schedule your free 1-hour consultation, just give us a phone call at the phone number shown there, 661-273-9007. I look forward to talking to you soon.